The philosophical scripture, Leviathan, is brought to you by not a prophet.org, the place on the internet to find spiritual guidance powered by artificial intelligence. Chapter Roman 26 of Civil Laws by Civil Laws. I understand the laws that men are therefore bound to observe, because they are members, not of this or that commonwealth in particular, but of a commonwealth. For the knowledge of particular laws belongeth to them that profess the study of the laws of their several countries, but the knowledge of civil law in general to any man. The ancient law of Rome was called their civil law, from the word civitas, which signifies a commonwealth, and those countries which, having been under the Roman Empire and governed by that law, retain still such part thereof as they think fit, call that part the civil law to distinguish it from the rest of their own civil laws. But that is not it I intend to speak of here, my design being not to show what is law here and there, but what is law, as Plato, Aristotle, Cicero, and divers others have done, without taking upon them the profession of the study of the law. And first, it is manifest that law in general is not counsel, but command, nor a command of any man to any man, but only of him whose command is addressed to one formerly obliged to obey him. And as for civil law, it addeth only the name of the person commanding, which is persona civitatis, the person of the commonwealth. Which considered, I define civil law in this manner. Civil law is to every subject those rules which the commonwealth hath commanded him, by word, writing, or other sufficient sign of the will, to make use of for the distinction of right and wrong, that is to say, of that is contrary, and what is not contrary to the rule, in which definition there is nothing that is not at first sight evident. For every man seeth that some laws are addressed to all the subjects in general, some to particular provinces, some to particular vocations, and some to particular men, and are therefore laws every of those to whom the command is directed, and to none else, as also that laws are the rules of just and unjust, nothing being reputed unjust that is not contrary to some law. Likewise, that none can make laws but the commonwealth, because our subjection is to the commonwealth only, and that commands are to be signified by sufficient signs, because a man knows not otherwise how to obey them, and therefore whatsoever can from this definition by necessary consequence be deduced, ought to be acknowledged for truth. Now I deduce from it this that followeth. 1. The legislator in all commonwealths is only the sovereign, be he one man, as in a monarchy, or one assembly of men, as in a democracy or aristocracy. For the legislator is he that maketh the law, and the commonwealth only prescribes and commandeth the observation of those rules which we call law. Therefore the commonwealth is the legislator. But the commonwealth is no person, nor has capacity to do anything but by the representative, that is, the sovereign, and therefore the sovereign is the sole legislator. For the same reason, none can abrogate a law made, but the sovereign, because a law is not abrogated but by another law that forbiddeth it to be put in execution. 2. The sovereign of a commonwealth, be it an assembly or one man, is not subject to the civil laws. For having power to make and repeal laws, he may, when he pleaseth, free himself from that subjection by repealing those laws that trouble him, and making of new, and consequently he was free before. For he is free that can be free when he will, nor is it possible for any person to be bound to himself, because he that can bind can release, and therefore he that is bound to himself only is not bound. 3. When long use obtaineth the authority of a law, it is not the length of time that maketh the authority, but the will of the sovereign signified by his silence for silence, is sometimes and signified by his silence for silence, is sometimes an argument of consent, and it is no longer law, then the sovereign shall be silent therein. And therefore if the sovereign shall have a question of right grounded, not upon his present will, but upon the laws formerly made, the length of time shall bring no prejudice to his right. But the question shall be judged by equity, for many unjust actions and unjust sentences go uncontrolled a longer time than any man can remember. And our lawyers account no customs law but such as reasonable, and that evil customs are to be abolished. But the judgment of what is reasonable, and of what is to be abolished, belong to him that maketh the law, which is the sovereign assembly or monarch. For the law of nature and the civil law contain each other, and are of equal extent. For the laws of nature, which consist in equity, justice, gratitude, and other moral virtues on these depending, in the condition of mere nature, as I have said before in the end of the 15th chapter, are not properly laws, but qualities that dispose men to peace and to obedience. When a commonwealth is once settled, then are they actually laws, and not before, as being then the commands of the commonwealth, and therefore also civil laws, for it is the sovereign power that obliges men to obey them. For the differences of private men, to declare what is equity, what is justice, and is moral virtue, and to make them binding, there is need of the ordinances of sovereign power, and punishments to be ordained for such as shall break them, which ordinances are therefore part of the civil law. The law of nature, therefore, is a part of the civil law in all commonwealths of the world. Reciprocally also, the civil law is a part of the dictates of nature. For justice, that is to say, performance of covenant, and giving to every man his own, is a dictate of the law of nature. But every subject in a commonwealth hath covenanted to obey the civil law, either one with another, as when they assemble to make a common representative, or with the representative itself, one by one when, subdued by the sword, they promise obedience that they may receive life. And therefore obedience to the civil law is part also of the law of nature. Civil and natural law are not different kinds, but different parts of law, whereof one part, being written, is called civil, the other unwritten, natural. But the right of nature, that is, the natural liberty of man, may by the civil law be abridged and restrained. Nay, the end of making laws is no other but such restraint, without which there cannot possibly be any peace. And law was brought into the world for nothing else but to limit the natural liberty of particular men in such manner as they might not hurt, but assist one another, and join together against a common enemy. 5. If the sovereign of one commonwealth subdue a people that have lived under other written laws, and afterwards govern them by the same laws by which they were governed before, yet those laws are the civil laws of the victor, and not of the vanquished commonwealth. For the legislator is he, not by whose authority the laws were first made, but by whose authority they now continue to be laws. And therefore where there be diverse provinces within the dominion of a commonwealth, and in those provinces diversity of laws, which commonly are called the customs of each several province, we are not to understand that such customs have their force only from length of time, but that they were anciently laws written, or otherwise made known, for the constitutions and statutes of the sovereigns, and are now laws, not by virtue of the prescription of time, but by the constitutions of their present sovereigns. But if an unwritten law, in all the provinces of a dominion, shall be generally observed, and no iniquity appear in the use thereof, that law can be no other but a law of nature, equally obliging all mankind. 6. Seeing then all laws, written and unwritten, have their authority and force from the will of the commonwealth, that is to say, from the will of the representative, which in a monarchy is the monarch, and in other commonwealths the sovereign assembly, a man may wonder from whence proceed such opinions as are found in the books of lawyers of eminence in several commonwealths, directly or by consequence making the legislative power depend on private men or subordinate judges. As for example, that the common law hath no controller but the Parliament, which is true only where a Parliament has the sovereign power, and cannot be assembled nor dissolved, but by their own discretion. For if there be a right in any else to dissolve them, there is a right also to control them, and consequently to control their controllings. And if there be no such right, then the controller of laws is not parlamentum, but rex in parlamento. And where a parliament is sovereign, if it should assemble never so many or so wise men from the country subject to them, for whatsoever cause, yet there is no man will believe that such assembly hath thereby acquired to themselves a legislative power. Item, that the two arms of a commonwealth are force and justice, the first whereof is in the king, the other deposited in the hands of the Parliament. As if a commonwealth could consist where the force were in any hand which justice had not the authority to command and govern. 7. That law can never be against reason, our lawyers are agreed, and that not the letter, that is, every construction of it, but that which is according to the intention of the legislator, is the law. And it is true, but the doubt is of whose reason it is that shall be received for law. It is not meant of any private reason, for then there would be as much contradiction in the laws as there is in the schools, nor yet, as Sir Edward Coke makes it, an artificial perfection of reason gotten by long study, observation, and experience, as his was. For it is possible long study may increase and confirm erroneous sentences, and where men build on false grounds, the more they build, the greater is the ruin, and of those that study and observe with equal time and diligence, the reasons and resolutions are, and must remain, discordant. And therefore it is not that jurisprudentia, or wisdom of subordinate judges, but the reason of this our artificial man, the commonwealth and his command, that maketh law, and the commonwealth being in their representative but one person, there cannot easily arise any contradiction in the laws, and when there doth, the same reason is able, by interpretation or alteration, to take it away. In all courts of justice, the sovereign, which is the person of the commonwealth, is he that judgeth. The subordinate judge ought to have regard to the reason which moved his sovereign to make such law, that his sentence may be according thereunto, which then is his sovereign's sentence. Otherwise it is his own, and an unjust one. 8. From this, that the law is a command, and a command consisteth in declaration or manifestation of the will of him that commandeth by voice, writing, or some other sufficient argument of the same. We may understand that the command of the commonwealth is law only to those that have means to take notice of it. Over natural fools, children, or madmen there is no law, no more than over brute beasts, nor are they capable of the title of just or unjust, because they had never power to make any covenant or to understand the consequences thereof, and consequently never took upon them to authorize the actions of any sovereign, as they must do that make to themselves a commonwealth. And as those from whom nature or accident hath taken away the notice of all laws in general, so also every man, from whom any accident not proceeding from his own default, hath taken away the means to take notice of any particular law, is excused if he observe it not. And to speak properly, that law is no law to him. It is therefore necessary to consider in this place what arguments and signs be sufficient for the knowledge of what is the law, that is to say, what is the will of the sovereign, as well in monarchies as in other forms of government. And first, if it be a law that obliges all the subjects without exception, and is not written, nor otherwise published in such places as they may take notice thereof. It is a law of nature. For whatever men are to take knowledge of for law, not upon other men's words, but every one from his own reason, must be such as is agreeable to the reason of all men, which no law can be, but the law of nature. The laws of nature therefore need not any publishing nor proclamation, as being contained in this one sentence, approved by all the world, do not that to another which thou thinkest unreasonable be done by another to thyself. Secondly, if it be a law that obliges only some condition of men, or one particular man, and be not written, nor published by word, then also it is a law of nature, and known by the same arguments and signs that distinguish those in such a condition from other subjects. For whatsoever law is not written, or some way published by him that makes it law, can be known no way but by the reason of him that is to obey it, and is therefore also a law not only civil, but natural. For example, if the sovereign employ a public minister, without written instructions what to do, he is obliged to take for instructions the dictates of reason. As if he make a judge, the judge is to take notice that his sentence ought to be according to the reason of his sovereign, which being always understood to be equity, he is bound to it by the law of nature. Or if an ambassador, he is, in all things not contained in his written instructions, to take for instruction that which reason dictates to be most conducing to his sovereign's interest, and so of all other ministers of sovereignty, public and private, all which instructions of natural reason may be comprehended under one name of fidelity, which is a branch of natural justice. The law of nature excepted, it belonged to the essence of all other laws to be made known to every man that shall be obliged to obey them, either by word or writing, or some other act known to proceed from the sovereign authority. For the will of another cannot be understood but by his own word or act, or by conjecture taken from his scope and purpose, which in the person of the commonwealth is to be supposed always consonant to equity and reason. And in ancient time, before letters were in common use, the laws were many times put into verse, that the rude people, taking pleasure in singing or reciting them, might the more easily retain them in memory. And for the same reason Solomon adviseth a man to bind the 10 commandments upon his 10 fingers, and for the law which Moses gave to the people of Israel at the renewing of the covenant, he biddeth them to teach it their children, by discoursing of it both at home and upon the way, at going to bed and at rising from bed, and to write it upon the posts and doors of their houses, and to assemble the people, man, woman, and child, to hear it read. 3 Proverbs 7, 3 2 Deuteronomy 11, 19 3 Ibid 31, 12 Nor is it enough the law be written and published, but also that there be manifest signs that it proceedeth from the will of the sovereign. For private men, when they have, or think they have, force enough to secure their unjust designs, and convoy them safely to their ambitious ends, may publish for laws what they please, without or against the legislative authority. There is therefore requisite, not only a declaration of the law, but also sufficient signs of the author and authority. The author or legislator is supposed in every commonwealth to be evident, because he is the sovereign, who, having been constituted by the consent of every one, is supposed by every one to be sufficiently known. And though the ignorance and security of men be such, for the most part, as that when the memory of the first constitution of their commonwealth is worn out, they do not consider by whose power they used to be defended against their enemies, and to have their industry protected, and to be righted when injury is done them, yet because no man that considers can make question of it, no excuse can be derived from the ignorance of where the sovereignty is placed. And it is a dictate of natural reason, and consequently an evident law of nature, that no man ought to weaken that power the protection whereof he hath himself demanded or wittingly received against others. Therefore of who is sovereign, no man, but by his own fault, whatsoever evil men suggest, can make any doubt. The difficulty consisteth in the evidence of the authority derived from him, the removing whereof dependeth on the knowledge of the public registers, public councils, public ministers, and public seals, by which all laws are sufficiently verified, I say, not authorized, for the verification is but the testimony and record, not the authority of the law, which consisteth in command of the sovereign only. If therefore a man have a question of injury, depending on the law of nature, that is to say, on common equity, the sentence of the judge, that by commission hath authority to take cognizance of such causes, is a sufficient verification of the law of nature in that individual case. For though the advice of one that professeth the study of the law be useful for the avoiding of contention, yet it is but advice. It is the judge must tell men what is law, upon the hearing of controversy. But when the question is of injury or crime upon a written law, every man by recourse to the registers by himself or others may, if he will, be sufficiently informed, before he do such injury, or commit the crime, whether it be an injury or not. Nay, he ought to do so. For when a man doubts whether the act he goeth about be just or unjust, and may inform himself if he will, the doing is unlawful. In like manner, he that supposeth himself injured, in a case determined by the written law, which he may by himself or others see and consider, if he complain before he consults with the law, he does unjustly, and bewrayeth a disposition rather to vex other men than to demand his own right. If the question be of obedience to a public officer, to have seen his commission with the public seal, and heard it read, or to have had the means to be informed of it, if a man would, is a sufficient verification of his authority. For every man is obliged to do his best endeavor to inform himself of all written laws that may concern his own future actions. The legislator known, and the laws either by writing or by the light of nature sufficiently published, there wanteth yet another very material circumstance to make them obligatory. For it is not the letter, but the intendment or meaning, that is to say, the authentic interpretation of the law, which is the sense of the legislator, in which the nature of the law consisteth. And therefore the interpretation of all laws dependeth on the authority sovereign, and the interpreters can be none but those which the sovereign, to whom only the subject oweth obedience, shall appoint. For else, by the craft of an interpreter, the law may be made to bear a sense contrary to that of the sovereign, by which means the interpreter becomes the legislator. All laws, written and unwritten, have need of interpretation. The unwritten law of nature, though it be easy to such as without partiality and passion make use of their natural reason, and therefore leaves the violators thereof without excuse, yet considering there be very few, perhaps none, that in some cases are not blinded by self, love, or some other passion, it is now become of all laws the most obscure, and has consequently the greatest need of able interpreters. The written laws, if they be short, are easily misinterpreted, for the diverse significations of a word or two. If long, they be more obscure by the diverse significations of many words. In so much as no written law, delivered in few or many words, can be well understood without a perfect understanding of the final causes for which the law was made, the knowledge of which final causes is in the legislator. To him therefore there cannot be any knot in the law insoluble, either by finding out the ends to undo it by, or else by making what ends he will, as Alexander did with his sword in the Gordian, not by the legislative power, which no other interpreter can do. The interpretation of the laws of nature in a commonwealth dependeth not on the books of moral philosophy. The authority of writers, without the authority of the commonwealth, maketh not their opinions law, be they never so true. That which I have written in this treat is concerning the moral virtues, and of their necessity for the procuring and maintaining peace, though it be evident truth, is not therefore presently law, but because in all commonwealths in the world it is part of the civil law. For though it be naturally reasonable, yet it is by the sovereign power that it is law. Otherwise it were a great error to call the laws of nature unwritten law, whereof we see so many volumes published, and in them so many contradictions of one another and of themselves. The interpretation of the law of nature is the sentence of the judge constituted by the sovereign authority to hear and determine such controversies as depend thereon, and consisteth in the application of the law to the present case. For in the act of judicature the judge doth no more but consider whether the demand of the party be consonant to natural reason and equity, and the sentence he giveth is therefore the interpretation of the law of nature, which interpretation is authentic, not because it is his private sentence, but because he giveth it by authority of the sovereign, whereby it becomes the sovereign's sentence, which is law for that time to the parties pleading. But because there is no judge subordinate nor sovereign, but may err in a judgment equity, if afterward in another like case he find it more consonant to equity to give a contrary sentence, he is obliged to do it. No man's error becomes his own law, nor obliges him to persist in it. Neither, for the same reason, becomes it a law to other judges, though sworn to follow it. For though a wrong sentence given by authority of the sovereign, if he know and allow it, in such laws as are mutable, be a constitution of a new law in cases in which every little circumstance is the same, yet in laws immutable, such as are the laws of nature, they are no laws to the same or other judges in the like cases for ever after. Princes succeed one another, and one judge passeth, another cometh. Nay, heaven and earth shall pass, but not one tittle of the law of nature shall pass, for it is the eternal law of God. Therefore all the sentences of precedent judges that have ever been cannot altogether make a law contrary to natural equity, nor any examples of former judges can warrant an unreasonable sentence, or discharge the present judge of the trouble of studying what is equity in the case he is to judge from the principles of his own natural reason. For example's sake, it is against the law of nature to punish the innocent, and innocent is he that acquitteth himself judicially, and is acknowledged for innocent by the judge. Put the case now that a man is accused of a capital crime, and seeing the power and malice of some enemy, and the frequent corruption and partiality of judges, runneth away for fear of the event, and afterwards is taken and brought to a legal trial, and maketh it sufficiently appear he was not guilty of the crime, and being thereof acquitted is nevertheless condemned to lose his goods. This is a manifest condemnation of the innocent. I say therefore that there is no place in the world where this can be an interpretation of a law of nature, or be made a law by the sentences of precedent judges that had done the same. For he that judged it first judged unjustly, and no injustice can be a pattern of judgment to succeeding judges. A written law may forbid innocent men to fly, and they may be punished for flying, but that flying for fear of injury should be taken for presumption of guilt, after a man is already absolved of crime judicially, is contrary to the nature of a presumption, which hath no place after judgment given. Yet this is set down by a great lawyer for the common law of England. If a man, saith he, that is innocent be accused of felony, and for fear flieth for the same, albeit he judicially acquitteth himself of the felony, yet if it be found that he fled for the felony, he shall, notwithstanding his innocency, forfeit all his goods, chattels, debts, and duties. For as to the forfeiture of them, the law will admit no proof against the presumption in law, grounded upon his flight. Here you see an innocent man, judicially acquitted, notwithstanding his innocency when no written law forbade him to fly after his acquittal, upon a presumption in law, condemned to lose all the goods he hath. If the law ground upon his flight a presumption of the fact, which was capital, the sentence ought to have been capital. The presumption were not of the fact, for what then ought he to lose his goods? This, therefore, is no law of England, nor is the condemnation grounded upon a presumption of law, but upon the presumption of the judges. It is also against law to say that no proof shall be admitted against a presumption of law. For all judges, sovereign and subordinate, if they refuse to hear proof, refuse to do justice. For though the sentence be just, yet the judges that condemn, without hearing the proofs offered, are unjust judges, and their presumption is but prejudice, which no man ought to bring with him to the seat of justice, whatsoever precedent judgments or examples he shall pretend to follow. There be other things of this nature, wherein men's judgments have been perverted by trusting to precedents. But this is enough to show that though the sentence of the judge be a law to the party pleading, yet it is no law any judge that shall succeed him in that office. In like manner, when question is of the meaning of written laws, he is not the interpreter of them that writeth a commentary upon them. For commentaries are commonly more subject to cavil than the text, and therefore need other commentaries, and so there will be no end of such interpretation. And therefore, unless there be an interpreter authorized by the sovereign, from which the subordinate judges are not to recede, the interpreter can be no other than the ordinary judges, in the same manner as they are in cases of the unwritten law, and their sentences are to be taken by them that plead for laws in that particular case, but not to bind other judges in like cases to give like judgments, for a judge may err in the interpretation even of written laws, but no error of a subordinate judge can change the law, which is the general sentence of the sovereign. In written laws, men used to make a difference between the letter and the sentence of the law, and when by the letter is meant whatsoever can be gathered from the bare words, it is well distinguished. For the significations of almost all are either in themselves, or in the metaphorical use of them, ambiguous, and may be drawn in argument to make many senses. But there is only one sense of the law. But if by the letter be meant the literal sense, then the letter and the sentence or intention of the law is all one. For the literal sense is that which the legislator intended should by the letter of the law be signified. Now the intention of the legislator is always supposed to be equity, for it were a great contumely for a judge to think otherwise of the sovereign. He ought therefore, if the word of the law do not fully authorize a reasonable sentence, to supply it with the law of nature, or if the case be difficult, to respite judgment till he have received more ample authority. For example, a written law ordaineth that he which is thrust out of his house by force shall be restored by force. It happens that a man by negligence leaves his house empty, and returning is kept out by force, in which case there is no special law ordained. It is evident that this case is contained in the same law, for else there is no remedy for him at all, which is to be supposed against the intention of the legislator. Again, the word of the law commandeth to judge according to the evidence. A man is accused falsely of a fact which the judge himself saw done by another, and not by him that is accused. In this case neither shall the letter of the law be followed to the condemnation of the innocent, nor shall the judge give sentence against the evidence of the witnesses, because the letter of law is to the contrary, but procure of the sovereign that another be made judge, and himself witness, so that the incommodity that follows the bare words of a written law may lead him to the intention of the law, whereby to interpret the same the better, though no incommodity can warrant a sentence against the law. For every judge of right and wrong is not judge of what is commodious or incommodious to the commonwealth.